Well, thanks everybody for coming. Go ahead and start. I'm just going to introduce everybody. I'm just going to start off with Rachel here. Rachel is a champion of systems reform, having served as an executive administrator in a nonprofit and state government for over 20 years. As a senior vice president of the PreTrial Justice Institute, Rachel works with national, state, and local system stakeholders to create partnerships, strengthen systems, and engage communities to advance safe, fair, and effective pretrial practices for youth and adults. Rachel spearheads the 3 Days Count initiative, acting as a catalyst for states to discover what's possible and create real and lasting change. A Florida native and resident, she began her career as a child abuse investigator and worked with foster care youth and their families in South Florida until 2008. She then served as the executive director of Yes Institute, providing communication and educational models to prevent suicide and keep all youth safe. Rachel has a Bachelor's of Arts from Emory University in psychology and political science and a master's degree in counseling psychology. She was a recipient of the National Association of Social Workers 2014 Citizen of the Year Award for Miami-Dade County. And Rachel? Do you want to just...
You want me to go ahead?
Yeah, I figure we'll just introduce and we'll let each person kind of do a little spiel, or should we? Yeah, all right. We're informal around here, guys.
Well, hello everyone. Thank you for the lovely introduction, and I have a commitment today to provide just a context of what's happening at the national level around pretrial justice, pretrial improvements, focusing... How do you turn it on?
Tap it, see if it's...
Better? There we go. Okay, we got it. Okay, we're mic'd. And so this context, I'm just going to spend just a few minutes and provide you with some of the research that has informed the movement around the country. And start with the ABA standards for the bail decision. I make no assumptions about who's in the room and what people know. But as you can see, it's about the integrity of the process. It's about due process. And it's about safety for the community and for the victims. It's important to remember the foundations of our legal framework as we embark upon any pretrial justice, whether it's at the local, the county, or the state level. Key landmark decision in 1987, one of the many ones around pretrial improvements, U.S. v. Salerno, and Chief Justice Rehnquist wrote in his majority opinion, in our society, liberty be the norm, but detention pretrial be the carefully limited exception. So we're going to look at what our country looks like as a landscape and whether or not this is in fact the case. A high-performing pretrial justice community, state, locality, we consider has the 3 M's, which is maximizing liberty, which most state statutes call for, a presumption of release. There are 29 states that are right-to-bail states. And with that, maximizing in that bail decision appearance, and in almost all states, except a few, New York being one, public safety in that decision. If we take a look at the jail populations, we saw about the prison populations just previously in the plenary. Rewind to the early 80s, our jails, about 2/3 of them were people serving convictions in the county jails, with only about 1/3 of those folks being detained pretrial, unconvicted. Fast forward to current day, these stats come, and by the way, anything that I cite today, I do have citations for, so if you're interested in them, I can point you to that direction. Fast forward to current day, about 2/3 of the people in our county jails are being detained unconvicted pretrial. The majority of those statistically are those charged with low-level offenses and misdemeanors. And if we look at the increasing jail populations since the early 2000s, 95% of the increase of our jail populations are those that are pretrial. These are unconvicted prior to adjudication. We can also look at many other factors. We looked at crime rates. 10 to 25% of the crime rate decrease may be because people are being detained either in jails or in our prisons, but crime is going down across the country. Violent crime, property crime is going down. And more people are being booked into jail. So if we look at back in the early 1980s, about 51% of the people arrested were actually booked into jails. Now about 95% of people who are arrested are booked into jails. There are some states around the country like New Jersey and other places like New Hampshire who are using citation in lieu of arrest, citing people for low-level offenses as one of the strategies. I think Miami-Dade has also employed that strategy. Now, around 2013, there's a really big shift in the pretrial justice movement that really shook the field. Any of us working in the field at the time, there was a series of research briefs that came out from the Laura and John Arnold Foundation that talked about the impacts of pretrial detention. And those detained pretrial, as you can see from these graphics, compared to those that are released within 24 hours, in most of those cases, it's because they can afford a monetary cash bond, which is the theme of the conversation that we're having today, are 4 times greater likelihood of a jail sentence, 3 times likelihood of a prison sentence, and then longer sentences for both jail and prison, 3 times longer and 2. So there's some dynamic in terms of people being released pretrial versus within 24 hours versus those that are being detained. Whether it's taking a plea, whether it's many suggest that it is. There's more research that needs to be done, but when you're detained pretrial and there are impacts on your home, your family, your job, many people do whatever it takes if they cannot afford the monetary cash bond to get out. And there are implications for taking that on in terms of system reform and the impact of case processing should more people be released inside of maximizing pretrial liberty. Also in a conversation around the national landscape is the disparate impact around race and bail and economic status. The research also shows that policing practices are an area that can be examined. There are many jurisdictions around the country that are reflecting upon this in their policing practices from the very front end of the system, showing that 2.5 times more likely African Americans versus white individuals likely to be arrested. And then if you look at the bond amounts along race lines, similar charges, similar backgrounds, similar criminal histories, African American men compared to white men, 35% higher bond amounts, and Hispanic men compared to white men, 19%. So there's disparate impact in both areas of policing and in the use of secured money bond for us to reflect on and identify areas to take on and tackle within Florida. Chief Justice Rabner, so New Jersey, did a major overhaul of their pretrial systems, and not that it is at all necessarily comparable to Florida. I mean, Florida is Florida, and we are unique in our own way, and we have eccentricities and court systems that are structured very different. However, there are some key components to reforms in states like New Jersey and in Kentucky and in Washington and in New Hampshire and in New Mexico that all can be identified as areas for us to look at and go to work on and identify as future solutions. Chief Justice Rabner, he identified that there's a problem at both ends of the system. One, the research from the Laura and John Arnold Foundation shows that half of the time, the highest risk individuals, those that pose a potential unmanageable risk to the community, are released pretrial because they can afford the secured money bond. And then meanwhile, those who remain detained in our jails, for the majority, are low-risk misdemeanor charges, what we would label as low-risk, low-level charges. And so if we look at our jail populations, and I'm glad Sheriff Hunter is here to talk about what he's done in Columbia County, If we look at our jail populations around the country, we are not detaining the people, in the carefully limited exception, with those that we care about the most being detained, those that pose that potential imminent risk to public safety and community safety, which is what we as Americans care about the most. Whether it's anecdotally or research, that is our top priority. The other, and as I wrap this up, the other major research that came out of the Laura and John Arnold Foundation in 2013 talked about the length of pretrial detention and the impacts of that. So this graph basically says, so all of the people in this study, it was a pretty vast study, were assessed on a pretrial assessment tool. Many judicial circuits here in Florida, not many, some, use pretrial assessment tools. And then they were categorized as low or medium risk to either appearance, public safety. And those who were detained 2 to 3 days as compared to someone who was released in most circumstances was able to afford the cash bond within 24 hours. 2 to 3 days. The likelihood of new criminal activity in the short term had a nearly 40% increase. And that's for someone who was labeled as low risk, typically low charges, limited criminal history background. 4 to 7 days, a 50% increase in new criminal activity in the short term, and 8 to 14, 56. And then you can see the statistics for the moderate risk. They did this not only for new criminal activity, but also for appearance rates. And they weren't as drastic, but significant increases in failing to appear in both of these respective columns. They also did this research aligned with 2-year recidivism rates. So post-adjudication, the likelihood of new criminal activity within a 2-year period, and the numbers went up. And what this really shook the field and said, well, what we're doing is actually producing the result that we don't intend. It's certainly not maximizing liberty by any means. And we're detaining people and then basically creating a perpetual impact of future new criminal activity, controlling for all other factors. And so this really shook the field and led us major policy decisions to be made at national stakeholder groups, you name it. They came to the table and said we need to really address pretrial and set up systems and policy statements for systems that actually produce what we care about the most. Finally, I want to talk about the use of money bond as we embark upon this conversation for Floridians. 2 studies revalidated the impacts of the use of financial secured money bond and the likelihood of being convicted, serve longer sentences, higher fines and fees, and even being arrested again. There's a perpetuality to the use of secured money bond in both of these studies. An additional study was done that said that there was no difference in terms of appearance or public safety whether the use of secured money bond or unsecured money bond. No difference. The same outcomes were produced. So as we go to work today and in the future, these are just some of the key research findings for us to consider and hone in on as we identify solutions for Florida. So with that, I'm going to turn it back over to Chelsea and the panel and be available as we continue the dialogue.
Thanks, Rachel. All right, I'm just going to go down the list again. We've got the Honorable Judge Kevin Emas. I know I'm going to Emas. Emas. Hey. He corrected. I know. If it makes you feel any better, I had a last name that everyone used to butcher, and that's why I married a Murphy. I kept it real simple. So he has the distinction of being appointed to the judiciary by 3 different governors. Governor Lawton Chiles, appointed by Judge Emas, to the Miami-Dade County Court in 1996. 5 years later, Governor Jeb Bush appointed Judge Emas to the Circuit Court of the 11th Judicial Circuit. On November 24th, 2010, Governor Charlie Crist appointed Judge Emas to the 3rd District Court of Appeal. As a member of the trial court bench for 14 years, Judge Emas served in the domestic violence, criminal, civil, and family divisions, and prior to taking the bench, Judge Emas was an assistant public defender from 1982 to 1983, an associate and partner with Fine, Jacobson, Schwartz, Nash, Block in England from 83 to 89, and a partner with the law firm of Thornton, Rothman, and Emas 89 to 96. While serving on the circuit court bench, Emas was an active leader in Florida conference.
Just call me Kevin.
All right, thank you. I'm just butchering it. Kevin was. Kevin. I'm just so sorry. This is why I can't have nice things.
But it's going in the evaluation, just so you know.
I'm not going to get pretrial. All right. Oh, sorry about that. All right. So Kevin has always been dedicated to legal education at all levels. Since 1998, Kevin has been a faculty member of the Florida Judicial College, teaching newly elected and newly appointed judges prior to taking their bench. He has taught at numerous statewide conferences for circuit and county court judges and has served as a faculty chair for Florida College of Advanced Judicial Studies, responsible for developing judicial education curriculum for trial court judges, serving in the criminal division. For 10 years, Kevin taught the Handling Capital Cases course, an educational program which Florida judges must complete before becoming eligible to preside over the death penalty case. Since 2005, Kevin has served as a faculty member of the National Judicial College, where he teaches the death penalty courses to civilian and military judges from across the United States. As an adjunct faculty member of FIU College of Law and the University of Miami Law School, Kevin teaches in the litigation skills program. He has coached mock trial programs at Coral Reef and Killeen Senior High Schools and is a mentor to justice teaching program. Kevin has partnered with high schools throughout Miami-Dade County to assist in mock trial programs, Teen Court Law Week, and other law-related activities and civics education in high schools. Appointed by Chief Justice Charles Kennedy. And
We all call him Charles. Yeah.
I'm going to call him Charles.
Yeah.
And reappointed by Chief Justice Ricky Polston, Kevin chairs the Supreme Court Criminal Court Steering Committee. He currently serves on the Florida Court Education Council and previously served as the chair of the Florida Criminal Procedure Rules Committee.
Oh, that's enough.
All right. He's got a great, fabulous bio. Can we give him a round of applause,
Thank you.
everybody?
Thank you, Chelsea. And
I deserve that.
I'm going to spend a lot less time than Chelsea did introducing me, talking about the topic, because I'm actually much more interested in hearing from you all. So I've been in the ivory tower for about 8 years now on a district court of appeal, but I did spend some time in the trial court, 12 years, and was a practitioner, though I've largely forgotten what that means. So I did have some experience in boots on the ground. And so when I was asked to serve on this panel, I really tried to think about what is the mission that we're here for with regard to bail and pretrial release. And so I think it's informed by two principles that I think we have to accept, or we can't really have a discussion. And the first one is the presumption of innocence, which we all give lip service to and we all think is important. But the truth of the matter is, right, as a practical matter, when you read the newspaper and you see somebody's accused of a crime, sometimes it's hard to give that person that presumption of innocence. But it's important and plays right into the second principle, which is the purpose of pretrial release is to assure the appearance of the defendant at trial or at hearings where the defendant's presence is required. So if we take those two principles and truly believe them and want to breathe life into them, it seems to me that the reason why we're here is, can we do this better? Are we doing it now as well as we can, but can we do it better? Can we maximize the effective use of pretrial release conditions without adversely impacting public safety and without adversely affecting appearance rate among defendants? And so I know that, number one, it's great that all the stakeholders are here, but whenever you invite all the stakeholders to a summit, which is kind of euphemistic for reform, right, Nobody likes to be scrutinized and nobody likes to be criticized. And I was reminded of that 2 years ago when the Tampa Bay Times came out with its expose called Bias on the Bench, which talked about implicit bias of judges at sentencing. And I had already been on the appellate court for 6 years, so I said, well, that's the trial court judge's problems, not mine. And then I went into the data and realized that all of my data was collected there. And I read it, and I said, that's not me. And I read that, and I said, well, that's not me. And I read that, and I said, well, the data must be wrong, because I didn't do that. And it took me, I would say, a couple of weeks before I said, you know what? I need to think about this. I need to think about it in the way that I handled the cases then, and whether we can handle it better and more effectively, and whether, in fact, there is an implicit bias on the bench throughout this state. And if so, what are the reasons why, and can we improve on it? Can we change it? And I'd like to think about pretrial release and bail in that same vein, with the idea that we're not here to criticize, we're not here to scrutinize, we're simply here to see what's the data we have, can we collect the data any better so that we're comparing apples and oranges, and can we do our job more effectively? That's really why we're here. I'm interested in hearing from all of you as well as my fellow panel members, and I thank you for being here and for the opportunity.
Thank you. Pop back over here to Kara. Kara is the legislative counsel for the American Civil Liberties Union. She's based in Tallahassee. She advocates in support of ACLU priorities, including criminal justice reform, immigrant rights, reproductive rights, LGBTQ rights, and freedom of speech. She previously served as the Senior Assistant General Counsel for the Florida Department of Economic Protection, where she represented the Department of Environmental Litigation and served as the lead employment lawyer and contracts attorney for the department. Prior to joining DEP, she was the Associate Director of the Legal Programs at the Florida Coalition for Domestic Violence, a statewide nonprofit domestic violence and advocacy organization. Kara.
Thank you, Chelsea. First, I just want to thank everybody here. I think it's really important that so many stakeholders are coming here together to talk about this. It's very rare that we have judges and state attorneys and public defenders and advocates and legislators and people on both sides of the political divide coming together to talk about this. Clearly, there is a criminal justice reform problem going on. The system is broken, and we all recognize that, particularly with regard to bail, because that's why we're here now, that there are a lot of problems and that we want to fix them. And as Kevin said, we're here today to try and figure out what is the best way to reach those mutual goals. From the civil rights and civil liberties perspective, I just want to highlight or go back to what you said in terms of, can everybody hear me first of all? Okay, I just wanted to highlight, there's sort of two things that we look at when we're thinking about bail and pretrial release. The first is the presumption of innocence, that you're presumed innocent unless you are proven guilty. And what's happening in Florida and nationally is that people are being warehoused in jails, behind bars, when they have not been convicted of a crime. So they are innocent, and yet we are taking them away from their families, we are taking them away from their jobs, we are taking them away from their child care responsibilities, and we are spending taxpayer money on housing them in jails and providing for food and medical expenses, and really disrupting the individuals' lives and their livelihood and their ability to return back to society when they haven't even done anything wrong that they've been convicted of. They are innocent. So the first thing is the presumption of innocence, and what does it mean when we are detaining people when they haven't been convicted of a crime. The second thing is we have in our system a two-tiered system of criminal justice. So there's a system for those with means, and there's a criminal justice system for those without means. And in our money bail system, if you have money and you have resources, you can afford to buy your freedom. You can afford to get out of jail. And if you don't, then you languish in jail and you're taken away from your family, from your job, from your child care responsibilities, and all of the impacts that has on an individual's life. And the mere fact of having bail be set means that there has been a determination, a judicial determination, that the person is not a threat to society, because you wouldn't have anybody go out into the community if they were a threat. So the mere fact that money bail exists means that the individual is not a threat to society, but yet we're locking people up and we're depriving them of their livelihood and their liberty. Sometimes it's been called wealth-based detention, the sort of two different systems that we have. I think of it more as wealth-based release and poverty-based detention. And I think it's there's a video I'm going to show right now that is just a couple minutes, but it's a documentary of New Jersey and what happened there. Because I think it's really relevant, because we're here today as the stakeholders to try and figure out what to do about this enormous problem that I think we all agree is not working for the vast majority of individuals who find themselves detained pretrial. And so in New Jersey, the same thing happened. The stakeholders came together. They had an enormous problem before them, and they worked together, and they were able to come up with a solution. It might not be perfect. It might not work for Florida, but it just shows that they were able to come together like we are here and ask the hard questions, and I think it's inspiring in that way. So if we can technically help us out.
The bail system in New Jersey was broken and it needed to be fixed.
The old system did not adequately protect public safety.
We need to have a system that doesn't treat people differently based on the size of their wallets.
Commercial money bail is one of the great injustices in this country.
My name's Tyler Hubbard. I'm 22 and we're at my Aunt Heather's house in Eatontown. The day after my graduation, I left to Pennsylvania to go to automotive technology school, and I had a job waiting for me when I got home. Being an automotive technician is a pretty good paying job. The longer you stay in it, the more you make. I have plenty of customers. I'm pretty busy. It works out pretty well. Basically what had happened, me and my mom's husband got into a big argument, and it ended up escalating in a way that it most definitely shouldn't have. That was basically my first time ever in the system. The charge was second-degree aggravated assault. I was mainly thinking, I hope I don't lose my job. I wouldn't have had anything when I got out.
Any time spent behind bars has serious consequences for that individual, for the family who relies on that individual, and more broadly, for the community.
They lose jobs, they lose housing, they lose connections to families and to communities.
And if you're not able to pay your child support, you're not able to pay tickets, it's very unlikely that you're going to be able to make bail.
My bail would have been upwards of $100,000, and I wouldn't really feel comfortable trying to gather that up from family members or friends.
Bail was set at $100,000 and you went to a bail bondsman, you might pay the bail bondsman $10,000. That is not money you get back.
When people can't pay back a bail bondsman, the bail bondsman coming after their assets, after their houses, if they can't pay it back.
This all really came to a head in 2013. The Drug Policy Alliance did this study. 40% of the people who were in county jails were there because they could not post monetary bail.
3/4 of the people who were being warehoused in jail were awaiting trial rather than serving a sentence. They stayed there for an average of 10 months.
Someone's whole life is derailed while they're sitting in jail pending trial.
People in the United States are so used to this commercial bail bond industry that they think it's normal.
Every country in the world has outlawed commercial money bail except for the United States and the Philippines.
It failed because it detained lots of poor people simply because they were poor. But the other problem was that there were rich people who were being released, even though they were dangerous, simply because they were rich.
No, I never had to pay bail. I would have been there a lot longer if things weren't how they are.
Our Chief Justice, Stuart Rabner, who put together his task force.
He called together what he called the Joint Committee on Criminal Justice. Judges, you had defense attorneys, you had civil libertarians, you had prosecutors, you had the Attorney General, you had members of the legislature, you had members of the governor's office.
There were some politicians kind of had to go toe-to-toe with them because some of them had differing opinions.
The goal of this committee was, let's pull together a blueprint for what became bail reform.
This was a piece of legislation that Senator Norcross and Senator Sweeney was trying to push.
And the governor had to call an emergency press conference where he came out and he was backed by urban mayors and people from across the spectrum who backed this measure. And he had to say to the legislators, get back in here and vote on this. And they did.
We have a ballot question in November that I'll be campaigning for and that I'm confident the people of New Jersey will support.
Here we had 2 Democratic senators and a Republican governor who said, I'm with that piece of legislation and I will sign it if you get it to my desk. It's too big, it's too hard. They have too much money. Well, all of those things were the case here in New Jersey, but we won. We won.
New Jersey is a couple steps ahead of the curve.
We're seeing already many, many more people who are not having to go to jail, keep being productive members of society while they wait for their day in court.
I think any state that has money bail should take a hard look at what we've done here in New Jersey. This is a positive example that other states can and should follow.
If you want to reform your state's criminal justice system, PreTrial is a great place to start. These are people who are presumed innocent.
Since I'm not in jail, I can continue working, follow all my dreams, and I want to eventually have my own shop, build a pretty good clientele base.
Because we have numerous other organizations working together, like-minded folks, we can get some great things done.
Next, we've got Tom Palermo, who is a assistant United States attorney in the Transitional Organized Crime Section at the U.S. Attorney's Office in Tampa. He serves as the Middle District of Florida's opioid coordinator and previously served as the senior litigation counsel to the criminal division. Tom came to the United States Attorney's Office from the 13th Judicial Circuit State Attorney's Office. Tom came to the State Attorney's Office from a federal judicial clerkship in the Middle District of Florida. Tom has tried at least 50 jury trials and received a Bachelor of Arts from American University, a JD from Florida State University, and a Master's of Law in Banking and Finance from the University of London's King College.
So I'm belated to the panel, so I appreciate you all allowing me to join. So a couple thoughts. One is I came from the state attorney's office and then went to the U.S. attorney's office. So I bridged the divide between state and federal and have seen how both systems work. And I guess for me, I would say first and foremost, I think the state of Florida does some pretty amazing things on pretrial release and detention hearings. The most dangerous moment I ever had as an assistant state attorney was about 4:30 in the morning when I'd wake up on my duty week to take a shower, run over to the courthouse, try to find the printer that was printing out all the CRAs, the criminal report affidavits, try to find the NCICs that were popping off the other printer, try to match the two of them together, to run over to appear in front of the duty judge on Saturday morning and to try to explain to the duty judge what had happened in each one of the events that I was about to get asked about, to try to read the Sanskrit that was the NCICs, and to try hopefully to keep both the judge and state court from going astray and from embarrassing myself and the state attorney. It was a fairly terrifying thing, and so the heroes to me at every detention hearing are those state court judges who are sitting there on the bench doing the best they can with incredibly limited information. And I say that because I'm a Fed now, and like the joke of, everything is gift wrapped and bow tied for us. I had 4 detention hearings this afternoon at 2 o'clock. We had pretrial services reports from our pretrial services unit that's run by the court system. The reports were no less than maybe 6 pages long. We had information about where the defendant grew up, where they worked, et cetera. the U.S. magistrate judges who are given the ability to render a decision about detention or release, they are armed with more information than a state court judge could dream of having for most cases. You know, I think so many of the things that the state does that's different from the federal system is just a function of the incredible volume that the state court sees. The Hillsborough County Courthouse does more cases in a week than the U.S. Department of Justice probably does in a year. The volume of cases coming in and out is extraordinary, and so, you know, the first thing I tell you is my hat's off to the state of Florida, to the incredible, you know, men and women who are making hard decisions with limited information and quickly. I'm not convinced that money bail is as broken as seems to be the trend in the conversation. The two principles that we apply when we're looking at detention are flight and danger to the community. And that's what we base our determination on as to whether or not someone should be detained or what the right conditions are for release. You know, the judge said he came from the ivory tower, but there is no ivory tower quite like the federal government, right? So I'll tell you, the first statute I could find that limited bail discretion on the courts was the first statute of Westminster in 1275. Which was followed on 414 years later by England's Bill of Rights in 1689, which prohibited excessive bail. So in many ways, history repeating itself, here we are talking about perhaps excessive bail. The Massachusetts Body of Liberties from 1641 included a right to bail, and the Continental Congress included a right to bail as part of the Northwest Ordinance. The first Congress passed the Judiciary Act, which provided bail with discretion except in death cases. Bail Reform Act of 1966 was actually driven in part by a concern about monetary bail, this concept that people, because they couldn't afford it, were being unfairly detained, which is how we got a massive reform, I think, in 1966 of the federal detention system. And we're largely still governed by the 1984 Bail Reform Act, which is what controls the federal determinations. We get a lot of cash bail in the federal system, but it's not the same as the conversation would suggest in maybe New Jersey. A lot of the cash bonds that we deal with are signature bonds. So defendant isn't actually putting up any money. It's the risk to the defendant that they may in fact have to pay this you know, notional $25,000 or $100,000 or $50,000, whatever the number is. You know, the magistrate judges here in Tampa have done a great job of kind of coming up with some innovative ways to address the concerns about risk, including signatures by, you know, family members, parents of the defendant on the bail paperwork. Again, it's mostly notional. In the 11 years I've been an assistant United States attorney, I don't think I've never seen us forfeit anybody's bail money. Now, people have had their conditions of release revoked, they've been taken in, but I've never once filed a motion to forfeit the bond. We just doesn't happen, at least in my practice. So take that for what it's worth. You know, New Jersey and now California, obviously they're eliminating cash bail. It's really sort of interesting to me to see the flip and rolls and the intersection of different folks in California who would otherwise be on polar opposite sides of the issue are coming together to oppose California's replacement of cash bail. I mean, who knows how it's all going to work. If Florida wants to do it, you know, it might be great for us to kind of see what happens in New Jersey and California and give it a little time to work out the kinks before we mess with the fourth largest state's, you know, cash bail system. But all I can tell you as a prosecutor, you know, look, I've been there. I've sat there at 5:30 in the morning trying to get ready for the bucket of release arguments that were coming, and just hoping I didn't mess them up. I wish you guys had a pretrial release system that was more like the federal system, in the sense that at least if everybody was armed with more information, the decisions that everybody was making about those you know, flight and danger to the community issues could be more easily addressed. It's just really hard to make that decision when all you've got is a CRA and a rap sheet that you hope is, you know, pulling the arrest for the right guy. So that's sort of my perspective. I would be really curious to see what everybody is thinking. You know, maybe some of the long-term changes in Florida might just be tinkering around the margins. Maybe it's the practices of each individual circuit that might bear some scrutiny. But if I could say, any one thing. It'd just be that my hat's off to the guys who are making those decisions. So that's it.
What? I was just going to finish introducing, but and then we'll open it up to questions. But if you're really dying to itch.
Let me just ask you this. In the federal system, how much time between the arrest of an individual and the magistrate hearing the bond issue?
So I can only talk about Tampa because that's where I practice. So some of the magistrate judges have a cutoff of 2 o'clock. So if an arrest comes in after 2 o'clock, it's 99% likely that person's going to sleep overnight in the Pinellas County Jail for a bond determination in the morning. We have to get the person to the U.S. Marshal Service. We aim for approximately 11 a.m. if we can, so that the marshals have a chance to process the defendant and the pretrial services has a chance to do the interview and prepare the report.
And I assume, unlike many circuits, there is no bond schedule that you deal with so that someone who is arrested can post bond before they see a magistrate.
So no, there's no bond schedule. I will say as a matter of practice, there are routine bond amounts given, especially on sort of common crimes. In other words, you just know, like, hey, I'm appearing in front of Judge so-and-so, more than likely or not, they're going to say $50,000 signature bond, and so we work it out fairly quickly with defense counsel. But there is not a schedule that they can post bail prior to being seen by a magistrate judge. We don't do that. It's an efficiency for the state, but in the federal system, that's not going to happen.
Oh, sorry. It's cheating. All right, last but most certainly not least, we have Columbia Sheriff Mark Hunter, who is a 24-year law enforcement veteran and Columbia County native and newly elected president of the Florida Sheriff's Association. The sheriff also is a retired lieutenant colonel. Sorry, I wrote this bio myself. He is also has a bachelor's degree in organizational management from Edwards Waters College, an FDLE Chief Executive Seminar, class of '43, and in 2009, and graduate FBI National Academy for the 256th session. And he has 30 years of service in the Florida Army National Guard. Did I do that right?
Thank you, Chelsea.
I'm never going to let that down. I'm going to change my business card.
Well, first I'd just like to say thank you for the invite to come and sit on this panel. It's very interesting, and from our perspective as far as a practitioner on the front lines, dealing with all the I would call it the hype. I think we know what we don't know. And the reason I say that is that I don't, we keep hearing all these numbers that are being thrown out there, and I don't think there's a consistency with the numbers and how they've been pulled around Florida. Matter of fact, I know they haven't been, because when we started talking about the reform, I actually looked at our jail and our numbers on folks that were to see if there was anybody so-called languishing in jail. And the raw data that we pulled out is we need to get a consistent formula across the state to be able to say how many folks when they bail, whether it's 5,000, 10,000, or whatever, and how long are they staying in jail. We found that ours were not languishing in jail. The problem that you have in there is the mix. You've got your VOPs, and as stated earlier, you have court-ordered child support, and those are being looked at as bail as well that are in there. So you wind up with somebody that didn't pay their $256.22. Well, they're arrested, or there's a warrant. They have to stay in jail until they pay that amount. Well, that's considered bond, and so that skews the numbers, but we don't see that we have folks languishing in our jail. It does us no good as a sheriff, who the majority of the sheriffs in the state of Florida are responsible for operating the jails, and it does cost money. The other number that was used earlier about the $60 a day for folks to stay in jail, that's a sliding number as well. I also sit on the Florida Model Jail Standards Commission or Committee, And that's one of the things we are working on now with a subcommittee, trying to get a standardized formula to say what does it cost to house an inmate in a county detention facility. And we should have that out this year, which I think is going to really help us. But what are the factors that are being used by every facility? You know, this is the standard. We're going to set the standard to say this is what you'll use to determine the cost of an inmate. When we get to looking at our jail populations, and I've heard some conversation earlier about the the use of notices to appear or the civil citations. We're already doing that. I do not have a pretrial program in my county, and I noticed it got real quiet in here, even quieter. But that's because we work with our judicial system. And the folks that are in there, when I pull the numbers to look at the 5,000 or less on the bail, if someone's not making bail within just a few days, they're already looking at a bond reduction for those people. And if not, looking to the judicial with our judges to be able to say, can we release this person? But there's going to have to be built-in discretion, because we do have violent offenders that if we do the brush stroke that covers everything, we're going to be releasing some people that are violent, and they're going to go back out, and folks are going to be re-victimized. The other thing too is that when we look at the pretrial, and let's not kid anybody here, this is going to cost a lot of money, and right now we're already, and I'm preaching to the choir here, strapped for funds to be able to operate as is within our court systems. And so when we throw these pretrial programs in there, that means we're going to have to hire pretrial officers. We're going to have to do these programs. I think it's great that they're doing a pilot program now, because I want to see how that works. I think they've Sheriff Galtieri is working on that now with that program. But I don't think we need to rush into this, and I agree with Thomas that let's see how these work with New Jersey, because all that's being painted up here about New Jersey, about it going so well, I do have the counter to that. One of the assemblymen up there, and I'm sure that you're aware of the assemblyman that wrote the letter to California, says do not do this. And in his letter that he wrote, he put in here that we were told that there would no longer be danger to our citizens because the dangerous criminals would not be released, and only low-level criminals would be eligible. The reality is that dangerous career criminals are released daily within hours of arrest. We should never have considered free bail to those who commit crimes where their citizens have been victimized. The other thing is that we've transferred the cost of the free bail to the taxpayers rather than to the offenders. And I guess I'm of the opinion that when folks offend, then there's got to be consequences. And I certainly, my job, I had an old sheriff told me once, he said, we've got the dangest job that you'll ever have in your life, Mark. He said, we work all day to put people in jail. And he said the very next day we're working as hard as we can to try to help those people and get them out of jail and get them put their lives back together. And I think that there's there's some inconsistencies around the state, and one brushstroke is not going to fix this. The larger counties, the larger cities, where they have such volume, we may need to look at something with those. But in your smaller counties and your mid-sized counties, I can tell you that the bail system works for us, because we work with our judges on the VOPs, making sure that those are not languishing in jail, that they are getting their hearings and getting them put before the court so that they can be sentenced and moved on to the appropriate areas or be turned loose. The bond schedule, I'm glad you brought that up. That's something that we do in our county. We have a bond schedule that and the deputies actually do have some discretion, but that baseline, they can't go above that. And a deputy does have the authority, or sheriff, to no bond someone until they go before a judge. And we need to maintain that discretion too, because things that go out here on the street, sometimes the deputies or the officers may have a lot more institutional knowledge, that person could be a danger back out into the public. And then it's not left totally with them. And within 24 hours, they're going to be before that magistrate or before that judge. So we need to make sure of that. But the VOPs I feel like we do a really good job of that. When I first came in, I've been sheriff 10 years now. When we first came in, we did have some overcrowding in our jails. We've got our public defender back here, Blair Payne, and we work well with him, even though he's on the other side. But most of the time, he'll fuss at me some like a good public defender's supposed to do. But I tell you, we have a very good working relationship. But I think, before we go into this, just it's broke in Florida. I don't think it is, and I think that we need to look at the recidivism rate and actually how many the failures to appear. I don't think that those numbers are being reported accurately out of New Jersey. Am I wrong about that, or do either of y'all?
They haven't reported.
Yeah.
They haven't. That's still yet to come. They've reported their jail population and release rates.
And so
Detention
I
rates
just
and
think
release
that,
rates,
I don't think that the numbers here in Florida at this time overall are supporting a whole, tear it all apart. I think that we need to go in and be very systematic with what we do. I think that part of this is working. The bail system, in my opinion, does work. I can tell you now that being in a smaller county, when I have my citizens call me, and they call me all the time, I'm sure a lot of you judges and all you other folks get calls, but when they call me and little Johnny's in jail, and he's got to go to work the next day, then I get on the phone and I go and I speak with the judge, and then we work at either getting that person released or getting a bond reduction to where that they can handle it. But they still need to have some consequences for their actions, and let's not forget that. They did something wrong to be put in jail.
They're suspected of doing something
Okay.
wrong.
Oh,
They're-
excuse me,
Okay,
just a second.
So,
Two things. One, I think we've got a special little lady in the back.
I can't see you. Where you at?
I'm right here. Hey,
There you go.
how are you? I mean, there still is a presumption of innocence.
Yes, ma'am.
So that's important to remember too, with all due respect. And I think you're right. I think small circuits and small counties are a different animal than, comparing your county with, Duval or Palm Beach or Miami-Dade. You don't really have the sheriff and the judge talking and saying how we're going to work this thing out. That's different. But I still think that there's a need for some consistency, even though one size doesn't fit all, and maybe a better job at collecting information so that we can gauge and make an appropriate recommendations throughout the state.
I think that basing your decisions or your way ahead on accurate information is imperative. I mean, when you're throwing the darts at the board, that's just not a good way to do business. We need to be able to be very precise with what we do, as most informed as we possibly can, and not just go in, I guess you would say, whole hog and just tear the system apart. Because I can tell you now, this has got some underlying things that are going to cost a lot of money, and that's what they have found up there in New Jersey as well, by hiring all of the PreTrial folks. The cost to the system as far as reoffending, those folks that aren't showing up. And when we set the court dates and all that, we're so tight scheduled right now when people are not showing up, and then we're having to reschedule the courts. I mean, it's a scheduling nightmare. So we've got to make sure that if we're doing this, that the folks are going to be showing up for court. And I will tell you this, it falls back on the sheriff's offices to be able to have to go back out and pick those individuals up. And then how many times do we release them if we go and pick them up for failure to appear? Do we just continue to release them out and then have to keep picking them back up? I mean, if you get a bite at the apple at pre-trial and you're released and then you come back in, then you had your time to do, and so then we'll hold you till you can see get to court. I mean, that may be too simplistic, but
I don't think that just, I think when you're talking about people with failures to appear, obviously that's taken into consideration when bail is discussed as to whether or not someone is going to be a flight risk. I think what we're also talking, and I don't know whether, we're saying, well, potentially violent crimes, what we're talking about also. But I think that we need to look at everything across the whole spectrum, first-time offenders, ties to the community with nonviolent offenses, as well as folks who are sort of recidivists. I mean, that's the beauty of review of it. And that doesn't mean that it's all going to tumble down, but the fact is, although it may be working very smoothly where you are, and because you have that wonderful relationship, it may not necessarily be working so beautifully all over our very big, diverse state. And that's why I think it's good to have a conversation.
And let me just say this, when we talk about, I have and I'm sure most of you do here, our probation and parole system. I can tell you now, if I was ever convicted and sentenced and had the option to do parole or either do straight time, which you will, there's no way in God's green earth that I would get on parole, because it is a system that is set up for failure for the people that go on there with all of the reporting, the monies they have to pay and all that. And that's one of the things that concerns me about pretrial is the cost that are going to be associated with that individual being out, or they're going to have to be doing monitoring on them, or they're going to be subject to drug test, different things like that. And who's going to pay for that? And if it's the individual, well, we're putting them right back into the situation.
Well,
where
speaking
they've got to
about
come up
that,
with
Sheriff,
money.
actually speaking about that issue, and I think that one of the issues, or one of the reasons why this whole panel was kind of tasked and what we wanted to kind of do is to bring some recommendations to the overall steering committee on pretrial and kind of discuss, obviously we've all kind of talked about some of our issues here. I kind of also forgot to introduce myself. I'm Chelsea Murphy. I am the Florida State Director for Right on Crime, and I was going to give a little suggestion. One of the priorities that we are going to propose this year is a little something called pretrial transparency, and it's a little something that I'm looking at this camera as in, I don't know where this is going to be put in, but I was 20 years old. I was arrested for a DUI, and I was booked into a jail. I will not say which county because I don't need anybody going to go look up my mugshot. But I was arrested, went through the whole booking process, and then went to see a pretrial officer. They told me, didn't see a judge yet. They said, all right, well, you qualify for pretrial release. I said, ooh, what does that mean? And I said, well, you can get out now. I said, I don't have to call mom and dad. I'm in. And okay, sign. So signed the paperwork, and there I go. Well, it turns out that my case was kind of good, and it took about 2 years before we closed. Well, 2 years of pretrial release, which was a lot of fees, calling, having to pay $5 every time you blow, paying $45, being on pretrial release, yada, yada, yada. So basically, this pretrial transparency, and being, Florida's a sunshine state, trying to keep everything in the sunshine, basically trying to give defendants, making sure defendants have their full options, knowing, understanding what they're kind of getting into. Here's your option for bond, here's your option for bail, and here are the fines and fees that are going to be associated if you choose pretrial. By the way, if you don't do these, you will end up back here. And so I think that everybody needs to understand their options. I didn't understand that when I signed that, oh, by the way, you're going to be doing blah, 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 blah. Now, if you're indigent, obviously that doesn't, it's a different situation, and that's great. But that doesn't always, each situation is different. And I think that also, we all have different views up here, and I like to say that even though I'm right on crime, I think that I'm a bit in the middle. I think that everyone has a role to play. I think that, Florida is a very unique state. I think that, the bail industry isn't going anywhere. Nobody shoot me. But I think that it's not going anywhere, and I think that the pretrial, and that's not going anywhere. So how do we all learn to be effective? How do we get there, and how do we make everyone, how do we do this all right? And so I think that the data transparency bill is a first step in the right direction. I think that the one that passed last year, I know that there's some kinks that they're working out, trying to figure that out, and Gypsy did a great job of her presentation today. But I think that trying to figure that out in little baby steps of trying to make sure that everyone can kind of play in the same level of field and not eliminate things, I think that's something to think about, and how do we be constructive? So, oh gosh, here we go. Yes.
The Florida Sheriff's Association will never denounce money bail or surety bail. I'm not officially speaking for the Florida Sheriff's Association. I'm Bob White, retired sheriff from Pasco County. But I will tell you that the Florida Sheriff's Association will never denounce surety or money bail. All the while, they'll never denounce pretrial. I had a pretrial program years ago, and I dismantled it. It was too costly. It didn't do what they said it was going to do. And since we dismantled the pretrial program in Pasco, it did not increase our bed status by one person, not one. So the problem that I have with pretrial release, if it's a universal concept, is I think, first of all, no judge really wants to do pretrial. Judge, would you go along with that? No judge really wants to do pretrial. I'm sorry, first appearance, excuse me.
No. In fact, frankly, I had a root canal the same day, and I chose the root canal over the bond hearings.
So I think what happens in the long run is if we have a universal pretrial program where you can't have money bail, you can't have surety bail, you will eventually have an appointed magistrate that will sit in pretrial, because he won't have to stand for election. He won't get the ire of the public if he doesn't let little Johnny out or little Susie out. The second thing is moms and dads will no longer be able to go down and get their little darling out of jail with a money bond. And I think that's going to be part of the problem. Then you have a bureaucracy that now is holding people in jail and deciding who gets out of jail. So I think in Florida right now it's working very well. We have pretrial and we have surety bail. And when you were speaking about the statistics earlier, I think we found out in the 2016 election that the population points are the East Coast and the West Coast. If we're taking data out of both of those coasts, we're not considering the heartland. I don't think we have any trouble in Florida, and to fix something that isn't broken might not be productive.
Right here behind you.
I'm the Chief Judge of the Ninth Circuit, and we've been working on trying to amend our administrative order that deals with pretrial release. It's a bond schedule. I want to talk just a little bit about the tension that is created by that. First of all, I'd like to say, I think everybody knows this, but Florida, the law in Florida is that almost everyone who is arrested is entitled to be released. Unless you've committed a capital or life offense and the proof is evident and the presumption is great, you're entitled to be released from jail. Now, whether that's pursuant to monetary bond or some other form of release, we release most people and care sometimes people who we even think might be dangerous, because we have to release some people even if we think they might pose a danger, unless the state has filed a motion for pretrial detention, which just doesn't happen very often in my jurisdiction. I don't know about the rest of the state. But the point is this. As everyone knows, in Florida, you're entitled to see a judge after you've been detained. 24 hours after your detention, it can be extended to 48 or maybe as much as 72 hours. A lot of circuits, myself included, have adopted bond schedules so that you can get out of jail between the moment of your release before you see a judge at first appearance. It's hard to write that bond schedule without it just involving money. And we've wrestled with this for a long time. My predecessor tried to amend that schedule to delegate to corrections officials, pretrial release employees, that if the person was scored low risk and low need on a risk assessment instrument, they could release them, and immediately the bond industry sued us for a delegation of our authority. And the county said, we just need to settle this because we don't think you're on solid ground, because it's unclear whether you can delegate that power to a non-judicial officer. And so what you could do is say, we'll just eliminate our bond schedule and everyone who's arrested will sit in jail until they see a judge, much like a federal magistrate, 24 hours later. As soon as I even uttered those words, my county said, are you out of your mind? Because you're just going to explode our jail population. You're going to cost us hundreds of thousands of dollars a year, so please don't do that. So we have a schedule between the moment of your arrest before you see a judge at first appearance that's driven by money. And I don't know, I think almost everybody does. The problem, and this is somewhat of our own creation, I think in my circuit and statewide, is let's take a brand new judge or a judge who's predominantly practices or presides at a civil court, and then they go to weekend first appearances, and they're going, I'm not familiar with the world of bond, and this person's been arrested, and I'm not even sure what to set, and so the bond schedule says $1,000, so I'll just reaffirm that $1,000 and let's keep moving. Not to mention that, as Tom said, everybody on the weekend wants to get out of there, before it's dark outside, and so there's this sort of rush to get through weekend first appearance. But we've sort of brought a problem on ourselves because I think a number of us, if we're honest, and by us I mean judges, do not follow the rules of criminal procedure or even our own statute by looking at what kind of release can I impose that doesn't involve money, which is the fourth criteria for releasing someone. And we've gotten a little lazy about it and just defaulted to monetary bond. And that's true for all kinds of reasons. Inexperience, there is a bond schedule that gives me some guidance. As the sheriff said, we had a case recently where a judge set a bond for an individual. Unfortunately, they got out and harmed someone, and the media put the picture of who on TV? Not the defendant who hurt someone, the judge who had the temerity to post a bond for someone who, by the way, was constitutionally entitled to bond. So you have these real-life pressures on the trial judges, as Tom said, with very little kind of limited information, especially on the weekends. You have this general entitlement to bond for almost everyone in Florida. And then you have these bond schedules that allow people to get out before they even see a judge. And marrying all that together to come up with a system that doesn't discriminate on the basis of wealth, which, by the way, I think is almost undebatable. We shouldn't discriminate about who do we keep in jail on the basis of wealth. That just seems to me to be something that's gainsaid. You can't say, well, I don't care if we discriminate based on wealth. But we do discriminate based on wealth in the actual implementation of our bond schedule. So I think we have to work on that. Now, I'm in a larger county than Sheriff Hunter, and so we have a lot of people coming through our jail, although because crime is down, we have a lot of capacity in the jail too. But releasing people into the community who are low risk, low need, and have low resources doesn't offend me. In fact, I think they should be if we follow our own rules that say the first form of release you should look at under our rules are releasing the person on their own recognizance, which kind of rarely, and then unsecured or a bond, and before you get to a surety bond. The bonding industry, let's all be honest about this, is very powerful. So they sued us as soon as we tried to delegate the authority to a non-judicial officer. And they, years ago, were successful in convincing the legislature that rather than set one bond for maybe 4 listed offenses that the police arrest someone for, you now have to set bond for every offense that a non-lawyer lists on an arrest affidavit as what might be charged. Which I only mention that as an illustration of kind of how powerful I think the bonding industry is. They're a pretty powerful lobby here. And so to kind of go away from monetary bond to some other system is going to be a political fight. I don't know whether there's the political will in Florida. But I do think we have to somehow figure out a system where someone is not sitting in jail who doesn't pose a risk to the community, but simply doesn't have $500 or $1,000 or $1,500. When someone charged with aggravated assault with a firearm who has some wealth got out before they even saw me because they could post a $5,000 bond, which was on our bond schedule. That just is not a logical approach to to both due process, fairness, and ensuring the safety of your community. But it's much harder to do, because if you eliminate your monetary bond, before you see a judge, you're going to catch hell from your county if you have any size. So I'm sorry I went on so long, but I just wanted to share those
Judge,
thoughts.
I just want to offer a couple comments just for consideration of areas to examine inside of your comments. So if you look and you know what the data is in the state of Florida of who those low-level, low-risk folks are in your jails, if you know that and they're evaluated, research shows with nothing more than a court reminder system, which is your least cost impactful pretrial service, have a 95% success rate of appearance statistically. It's just probability. There are always exceptions to human behavior, and there is no perfect system, whether you use monetary cash bond and are unsupervised, or whether you fall into a system like New Jersey. But for consideration is identifying who are those, measure them, know the probability of success and that there is still always human behavior, and preparing your community for that. The other are going around on various jurisdictions are ability to pay determinations. There's no yet good model ability determination available yet, but many jurisdictions around the country are integrating that. The other force that may be upon Florida likely in the next few months is litigation. There are 4 pending cases, one which we anticipate a more formal ruling that may call for the immediate non-monetary release of all those charged with misdemeanors in the state. So whether you choose to approach pretrial improvements in a methodical way and sort of identify what the priorities are or not, there may be forces beyond that we've seen in jurisdictions and states around the country where you're going to lose the ability to control it because of the force of litigation. You also have obviously legislation, which is and potential court rule changes. So there are many different avenues, but I just wanted to offer ways to approach that with good data, limited use of resources. I do want to say one thing, and then I'll turn it over to anyone else who wants to comment. I mean, I know we're talking about New Jersey, but they release 95% of their jail population, those that are arrested. The majority were cited and really, hey, you got cookies for me? I mean, bring the cookies over. There is no perfect system, so there are going to be things that happen because you're dealing with only probability. They use an actuarial pretrial assessment tool. It's a national tool that's been validated. It is not a replacement of monetary bond schedules nor of judicial discretion. And so it's important to know what things are and what they're not as you identify what's best in Florida, knowing what the data is around your jail population. Yes, sir. 48 hours if you're booked. So they have 2 different kinds of summons. They have a summons that is basically a citation in lieu of arrest, and then they book you into jail. Only 44,000 people were actually booked into jails of the 150,000. The rest were cited and released. This is your 2/3 low-risk misdemeanor charges.
So you're booked into jail, you are a misdemeanor, you are low risk.
You don't go in. You're cited and released. Those nonviolent, right.
I don't know what category of felony you have in New Jersey, but for us, a 3rd-degree felony, let's say it's a property crime, and you also score low risk, low need. In New Jersey, you would sit in jail till you saw the judge.
Typically, my guess is those folks are being screened out and cited and released. They may not be booked. They have immediate data. So this is where data and the 1392 will help inform real key factors. They have a pretrial assessment tool that is static data that then can help determine who actually goes and books into jail.
And that's a legislative determination. In other words,
That's
the
correct.
legislature said if you score low risk, low need for these levels of offenses, you are released.
I don't know if the legislature actually decided what those cutoff points were, or if that was the administrative office of the court. And
the reason I ask is we have that delegation issue. Can I, as a judicial officer, delegate the decision to someone else other than a judicial officer no matter what you use, a risk assessment instrument or whatever?
There are jurisdictions that have the police that are working in conjunction with the court system. So everybody's at the table to design that and that framework and that the decision-making framework in unison. Anyway, thank you.
Yeah, go ahead.
Does anyone on the panel have the data on the 67 counties around the state of Florida and whether they have a pretrial release program, number one, and number two, whether that program costs money? Because I think that's where we need to start. We have a pretrial release program in my county. I've been a county judge for 6 years, and I'm actually the one who advocated to my county commission to create this spot because at the time our jail population was through the roof, and we were in the process of building a new jail, but it was going to be 3 or 4 years before that took place. And it's been fabulously successful, does not cost the offenders any money. So I think in order to have this conversation, we need to start there. With our 67 counties, obviously populations vary, but how many of them have some type of pretrial release program, and then does that program cost the offender money, and start the conversation from that point?
I believe there are around 30 of the 60.
Flagler.
32 pretrial programs that vary drastically.
Yes.
Drastically in terms of resources, in terms of whether or not they use an assessment tool, in terms of whether that tool is even validated locally in the state of Florida. And then most of them, and I'm going to assert this because I've worked and sat in first appearances in many counties in this state, that people are over-conditioned, much like Chelsea's experience, that if we're going to utilize resources and you want to build, if you want to build pretrial services programs, that you understand the impact of those resources where it's going to make a difference. It should not be over-conditioning low-level, low-risk folks, those people evaluated as low risk on a pretrial assessment tool, because then you're going to start creating pretrial failures. You do not want to put your resources on people who have already a 97% chance of appearance in public safety. You want to focus it in on those other populations that actually demonstrate success when you do supervise them in some manner or not. So it varies, and justice varies by county and by judicial circuit in the state of Florida. But I'll assert that we're not utilizing those that do have the resources in the most effective manner, and will differ quite significantly from judicial circuit to judicial circuit. I don't know the costs. I don't know the costs by county or judicial circuit for pretrial programs.
And just
I don't know the answer to that either.
Because in my county, the offender doesn't pay anything. They don't even pay for UAs if I order UAs.
I don't know the answer to that for Florida. Yeah, and it's an important thing if we're talking about ability to pay. Most people that are getting those.
I think Opaga had put something out. I believe there's something, but again, it's kind of skewed.
It varies
like,
by county.
It varies.
The answer is it varies by counties. The county programs vary from time to time. I'm Circuit Judge John Stargell from the 10th, and I'm also the legislative chair this year. I've been the legislative chair for about the last 10 years for the Circuit Judges Conference, and I'm a recovered legislator. I want to talk a little bit. I'm glad she asked that question, because one of the things that's been interesting over the last few years is our state is so diverse in so many ways that I'm sitting here next, and I didn't know, I knew Nancy Daniels for a long time, and it just met the new the new public defender for the Second Circuit. My public defender is sitting right behind him, and I'll give you a perspective. I'm from kind of a tweener county. Polk County is large enough that we have a pretrial release program, but when I do weekend first appearances, at the end of doing what's about 80% of our workload is Polk, then they turn on the little cameras, we switch to someplace else, and we go back about 20 years to Hardy County and to Highlands County, 40 years, whatever, and their eyes get big and they're like, whoa, there's a TV and there's a judge way up there that's going to do this for me, and they don't have pretrial release, and I don't have the same information. And what's been interesting for me is being from a tweener county is we go to conferences and we have the people from South Florida who have all of the resources and all the different programs. And then we're kind of a middle size, and then you get these small areas, Alachua, you get Lake County, and those areas where they don't have those resources. And I appreciate hearing Sheriff White's perspective on pretrial. There's a lot of judges who don't like it, but I look at it like this: it's information, and the more that we can get information to the judges to make those decisions, what they do with it then, that's what they're elected for. And this risk assessment model that they're talking about, we've been working on the last few years, it all comes down to technology and availability and getting that information together. And I think one of the areas we can really all focus on in the next few years is technology, because right now, this sitting in front of me is brand new. For years, I would go up to Tallahassee and I would see Fred there, and he'd have all this great technology from Orange County because they fund him. And Bob Roundtree from down in the 8th Circuit, he'd have all this great technology and talk about what his program was doing. And I was like, we don't even have a program that allows us to research within our 3 counties, that sort of thing. So the more we can get the message to the legislature, and I'm trying as much as I can, that if you will give us the technology dollars in the court system and allow it to happen. Right now, Fred Lawton, who just spoke to you, we've been working together on a remote interpreting project, so that now the same people who can't get interpreters in some of these small counties, we'll be able to show them on a screen. Once again, voila, this sounds like something, but we now Skype with our grandkids and our kids, but we can't use that technology in the court system. That same thing could be used in pretrial release. Just because somebody can't get to all 7 counties or 12 counties that these people represent doesn't mean that somebody can't walk in with this tablet or sit in a room, a remote room that they have at their jail, and interview people, so that, because that's what happens in Polk County. People show up at 5 in the morning and go actually physically interview them. But they could interview Hardy and Highlands County by putting the people in a room with a tablet, but we just don't do it. We don't have the resources, and we don't have the trunk lines to get that space in. So I'm sorry, I've said enough, but if we're talking about what we could do to fix things, we need to start with using the technology that's available to us and make sure that judges like us all have the best information.
May I?
Over the gentleman over there has had his hand up for quite a while.
I will cede to the public defender from the Second Circuit.
I think I should defer to the judge.
I just had a quick question. When New Jersey did its overhaul, did it also contain an appropriation to go to all the counties?
An appropriation meaning to fund the pretrial services? Yes. I don't know if it was individually appropriated, but basically it did fund. I believe it was through a tax to have statewide pretrial services that were consistent throughout the entire state. The resources would be allocated as needed by the county. No, they don't have their detention costs anymore. But in terms of the resources that were needed, yes, they also spent a lot of time building the resources in the community and recognizing that there's a needs element that isn't really being met when you detain people pre-trial, whether it's substance use or mental health. And so there was a preparation throughout the state to make sure that the community could receive those that had service-based needs that sometimes landed them more facing the criminal justice system, where otherwise could be diverted into community resources.
Can I just throw in as well? In the federal system, we do that all the time, right? I mean, when you're released, we're including mental health evaluations and treatment, drug evaluation and treatment. Those are sort of standard things where we try to get our defendants some assistance, if you will, early. I mean, it's not about a prison sentence at the end. I mean, in theory, it is about doing justice, right? There may be a prison sentence at the end. That may be a significant piece of the punishment. But we're trying to do those things. The thing I always worry about with the state is just the unbelievable lack of resources that you all face by comparison to what I face in the federal system. We are club fed by comparison. I'm not going to kid you. But I don't know how you guys do things on such a shoestring. I mean, it is incredible to me. The other thing that I remember when my friend Sergeant Ron Harrison was murdered by a gentleman who was out on release. That was a bad day, and a judge was confronted in his driveway by a national television news program over the issue of release. I mean, those decisions are they're significant in the state. These are really sort of weighty issues. And I mean, it is interesting to have like New Jersey's system of having a computer pop out a number and give you some risk assessment. But the God's honest truth is, you just don't know which one is always, it's the wisdom of Solomon or beyond to figure out who the guy is who's going to be the one to kill somebody or not. I mean, my domestic violence defendants, when I was a misdemeanor prosecutor, every 3 weeks I was called up to the chief assistant's office to explain why the guy was out on release because he murdered somebody. I mean, those are realities that the state court system faces. So when you talk about pretrial release and pretrial detention, I mean, it is just the biggest, scariest piece of the puzzle sometimes. And the amount of data you guys have is so incredibly limited, which is why to me it's really exciting to hear about a pilot program collecting data in 2 counties to at least give you a better picture. I mean, at least the magistrate judges have in the bail report, some information about a defendant's ability to pay. In theory, it's self-reported, but we get a sense of how much, what assets they have and what their income is. I mean, you guys are really working under the gun, and we're here in Florida too, but in the federal system, and I can just tell you, I know it's expensive, I get it, but you guys might benefit at least a little from some of the things that we've had available to us for a long time in the federal system. And I gotta say, just as somebody who's here today and seeing some of what you guys are talking about, it gives me a lot of faith as a Florida lawyer to see you guys in here having this conversation because, somebody's gotta be thinking about the long term, the health of the Florida criminal justice system. And it's exciting to hear you guys throwing out these great ideas that might lead to some positive changes out there. And if nothing else, though, if you want to give some support to somebody, give some support to your judges who are making those hard calls and try to give them the best information you possibly can so when they have to make the bail and detention decisions, they've got the information they need to make a good one. So that's my one call for change, if I could.
Well, the thing that's interesting too is this thing is so multifaceted. And when we look at, bail for different individuals, and I know there was some talk about an algorithm they were using to be able to fill out the score sheets that they were trying to develop, some of the things that they were, and that's got to be tweaked some as well up there. But, when you take in, for instance, the limited services that we have, especially and I keep going back to the smaller counties, when you have someone acting out that has mental health issues, we take them over and we have a mental health facility. We take them over there. They're out before our guys are even finishing the paper. They answer their questions right, and usually the first thing they're asking them is, what insurance do you have? That kind of determines which way they're going with this, whether they're going to be able to go to a facility, a private facility. The state facilities are usually always filled, so they'll release them right back out. After about 3 times in a night, they're going to do something that's going to violate the law, and then they wind up at the detention facility. So then they're on our watch, and so it gets really problematic that person, if they're out there doing criminal activity, if we release them back out, they're going to go right back to what they're doing. But that's not the issue. It was their act that they were doing. It's that they need help for mental health issues. And so, this thing, it's a bigger picture, and especially, and I know I've talked to some of the larger county sheriffs, and they have a lot of resources, but still they're struggling trying to fix those different slices of the pie that are within this whole picture.
And if resources are an issue, which they clearly are, I mean, that is something that we can do as part of our mission is to have our legislative request to that we need more resources to address these needs. And so we can't just say that well, we don't have the resources, small counties don't have the resources, people on the resources, and so therefore we have to lock up people who have been accused and not convicted because they don't have the ability to pay for their bail. I mean, that can't be the answer. The answer can't be that we don't have the resources, so therefore poor people have to be criminalized. Poor people have to suffer
What about
from
the
that.
folks that are?
We can ask for
what about
resources.
the drug offenders that you have, that the judge sentences them to an in-house service that they have to, and then they tell you that they're going to tell you the beds are full. So now the judge has to put them on house arrest. So they send them to the house. Well, now we're putting them right back into the environment, and they're going to violate again. And that's the the cycle that keeps coming back around. And that's what one of the things that's really frustrating as a sheriff that why can't we get some more facilities allocated that we can put these people out where instead of in jail. They don't need to be in jail. But we're winding up, I mean, the sheriffs are the ones that are winding up having to tote the load because they're the societal issues, but it all winds up back with us. And we're trying to do the best we can, and I'll tell you right now.
Well, which I think goes to her point, which what she was saying, which we need more resources for mental health, substance abuse, and that kind of thing. So an appropriation or something like that would be.
How do we get that pushed through to get some more facilities for us?
Right. And also just to clarify that, we're not talking about having dangerous people be people that are that there's clear and convincing evidence that they are going to be a danger to society. We are not talking about releasing them. Those people will be detained as per our Constitution, as per our Florida statutes. People that pose a threat to society will be detained. We're talking about people that there is not evidence that they will be a threat to society. So there's low-level misdemeanors, there's nonviolent offenses, there's a whole range of people that are being locked up.
I do have to say this, when you look and you go up there, some of the websites with the folks that are countering the New Jersey stuff. I mean, we have to be honest with that's what we're doing here is talking. They're talking about the fails within the system too, about the different ones that were released that were violent offenders.
But we have that today. If you can afford bail, you get released. I mean, it's just a two-tier system.
Yep, I think we got three
hand
questions, and then we'll wrap it up. Scott.
Yeah, just real quick. I want to shift us back real quick to, and sorry, everybody can't see me. To the issue of money bail. And what I want to ask the panel, and frankly anybody can answer this question if they have it, there's this assumption that money bail is necessary to protect public safety and to ensure that people return for their appearance. But we're making that assumption, but what evidence is there that money is the critical component in assuring public safety and people returning for their dates? So if anyone who is kind of defending the current money bail system could share with me the evidence that proves that, I'd love to hear what it is.
As a judge, the one thing that money bail does for us is if somebody isn't there, the bondsman goes and finds them and picks them up and brings them back. That is a critical element that we don't have otherwise, because then we just issue a capias and never see the people again, and then it's on the bondsman. They then give the money and the resources. So that's one of the elements that I think that offers that pretrial release and other things don't.
And then if that bond system is not in place, then that would fall back on the sheriffs. And we're already constrained with our resources that we would have to take that role up to serve those warrants.
And your question is how often? I don't know. I was a felony judge for 7 years and VOP for a year, and a number of times the bondsman would go out and find people. I had one that skipped on a $100,000 bond out of the country, and they got him and brought him back.
I think that's something that you're going to have to weigh in terms
I think
of that.
She's been waiting over here.
In terms of that outcome, there is no research that suggests, at least now, nothing there that suggests money produces a better or improved income than no money. In fact, what it shows is that the use of unsecured signature bonds produce the same outcomes in terms of appearance and public safety. And when polled, we just released some polling with James Madison Institute and Project on Accountable Justice and the ACLU about how Florida voters feel. Overall, nationally and in the state of Florida, public safety is the #1 concern. And recognizing appearance is an issue. We want people, but the risk of flight compared to the potential impact to public safety is minimal in comparison. So that's a decision that you're going to have to explore.
And you anticipated
prioritize.
the wrong question. My question was, how often, if the bail bondsman doesn't bring the person back, how often do you go and you get the full amount from the bail bondsman? How often does that happen?
Yep, they're on the hook for it.
I mean, it is their money.
Yes.
Don't get her the mic.
Oops.
Okay, perfect. Get her the
Someone's
mic.
off duty back there. Chelsea will entertain in the meantime. 10 minutes, okay, all right. It's coming. It's coming.
I think I had the pleasure of sitting on a committee with the sheriff and a lot of other stakeholders when we first started talking about pretrial services. And pretrial services started, I said I would agree as a judge to try out pretrial services for misdemeanors. And I think the conversation with the sheriff and other people around the table initially was, these are how many people we have in our jail. We had someone do that. Here are the people that are considered nonviolent. Would you consider trying a pretrial program that would release some of the nonviolent offenders? Of course, it came with someone who, a correctional officer who worked in the jail. And what the jail did, they did like an initial screening. So they would tell me, Judge, this person has been arrested this amount of times, they're violent, they have this amount of contacts with the community, da-da-da-da-da. Our sheet has several things. It has some basic conditions, but you can also add conditions. And this had not been tried with DUI offenders. So what we did, what are we trying to do? And that's part of the analysis. So Duval is a large county. And when you do pre-trials, you can have 7 to 10 DUIs in the morning and maybe that many in the afternoon. So what the sheriff, and this person worked for the sheriff, so this is kind of your question. What are you looking for? What kind of restraints do you want for this person? And of course, you want to protect the community. Well, you could limit that. And then if that person comes back, the jail would send a violation in and say, well, this person was either drinking or had other offenses. And then you could reconsider what you wanted to do. Now, bail, I've been a judge for 20 years, a county court judge, and we all have to serve in first appearances and sometimes on weekends. But I can tell you that it's very helpful to have someone in the sheriff's office who screens the person either through NCIC or the like and says, Judge, this person is low risk, or this person is a fugitive from another jurisdiction. And that gives me the ability to make that kind of decision. I really liked what I heard from the federal system, because what are we trying to do? We're trying to protect the community and guarantee appearance. Well, if somebody's arrested for trespassing and they have a 503 bond, and another person is arrested for trespassing, what does that mean? If a person is trespassing, yes, he may go back to that same place, and it may have you pick them back up again. But see, then again, a decision can be made. I don't know what the statistics are. They said $64 a day to keep someone in jail. It may vary in your county, and perhaps an analysis would be, if I can save money by not housing this person, how much would it cost to staff a pretrial? Then that's some kind of the dialogue that has to start. It didn't start with the sheriff or this person. It started with a lot of people sitting around the table deciding. Now, the mental health issue, we're kind of on the bottom on that, and I can understand your concerns about mental health. I concur with you that people with mental health issues don't belong in the jail, but as a misdemeanor judge, there isn't a statute other than that 72-hour that gives me the ability to do that. Do I wish there was more support? But I think in a discussion when we're talking about pretrial release, we're talking about the majority of the people who may not fall into that category. And we have to ask the question, what are we trying to accomplish? Can we get people who don't belong in jail out and yet protect society from those people who really need to be in there? And I guess a good statute to look at would be the domestic violence statute, which says that they come to every first appearance, and the judge has to make a determination based on information whether or not that person should be released. And for years, it was either you get out or no bond. Because if you're going to kill your spouse or your other significant other, whoever it may be, no bond is going to protect that individual. So I think having that data, that kind that you get from the federal system, but looking realistically and working with the county commissioners, working with the sheriffs and their population, understanding what's there, getting that data, having someone say we have this many people in. The same thing like we kind of did in Duval County. Is it perfect? No. But what we are doing is trying to work together, the judiciary, the sheriff's office, and everyone to see what is going to benefit us and how can we do that. And that's why I appreciate hearing everybody's feedback. And so what I would say to you, Sheriff, you have a genuine concern, but perhaps there's something or a bridge with the judiciary or with others that perhaps you can get to where you're going.
All right. Anybody else? In the back? Speak now. No. Oh, you got one? Oh, yep.
I really didn't want to say anything, but I just want to add something. My name is David Dink, and I'm a county judge out of Sarasota County. If we're going to take this seriously, pretrial release and bond, then we need to start putting more experienced people to do those jobs. There is nothing more frustrating than sitting as a first appearance judge. By the way, I counted about 15 judges here, and I assume all of you have done first appearances at one time or another. And I guarantee you that every one of you, at one time in your career, went home after doing first appearances, and at 3 o'clock in the morning, you wake up in a cold sweat going, did I make the right decision? Because I really didn't have enough information to make that decision on. Judges can't get enough information at pretrial services. We just can't get enough. When we're doing first appearances, usually we get the brand new prosecutor and we get the brand new public defender. And here's what we hear from the brand new prosecutor. Judge, I want you to set a reasonable bond. And that's it. Well, thanks. I was going to set an unreasonable bond, but now that you mention it, I'm going to set a reasonable bond. You were a lot of help. Or the other thing is when you get a brand new prosecutor or a young prosecutor and they say, well, Judge, this is serious. He's a danger to the community. I want you to set a high bond, $5,000, because they don't have a concept of what it's like to schedule a bond and what bond is for. Public defenders. Sometimes we get the brand new public defenders. Every case, they want ROR. Well, every case isn't ROR. We have prosecutors that ask for, Judge, we'll give them time served or we want a bond of $5,000. Well, that doesn't make sense. If you're offering time served and they want to challenge the charge, then shouldn't they be released on something other than a $5,000 bond because you're saying, A, the crime's not serious and they're not that serious to be in jail any more than today. So all these things we need to consider. So we need to have judges that show up early. I know all the judges here, and when we do first appearances, we show up early so we read all the probable cause affidavits so we know what we're there for. I have the help of pretrial services. Our defendants don't pay for pretrial services. If they're assigned to pretrial services, they don't pay anything. And my pretrial services, it's based on the Virginia tract, and what it does is it gives me a scoring, ROR, RR with conditions, low SPR, medium SPR, high SPR, or that if it's really serious, they say, you figure it out. And what it says is just court. It tells me their employment. It tells me their family history. It tells me their prior record. It tells me their arrests with no convictions. And for domestic violence cases that Pauline brought up, the statute provides that even if you're acquitted of a domestic violence charge, the prosecutor has an obligation to let us know about it, and we have an obligation to consider that. That's all the information that helps us in making our decisions at first appearances. Pretrial services should be available in every single county. It just, I heard from the federal prosecutor, you can't have too much information. You can't emphasize that enough. We need to have that information, and Judge Stargell made a good point. Every year he goes up to Tallahassee and says, we need money for technology. We need judges and law enforcement to have this information so that when we make these decisions, they're informed decisions. And every year it comes back with, well, we don't have enough money. So if we're going to take this seriously, then we need to put the right people at the job, and we need to put money behind it. Thanks.
Judge, you make a really good point that, I mean, there's about 40 different decision points pretrial start to finish. I mean, and we've talked about many of them, everything from the use of secured money bond versus unsecured, preventive detention, pretrial services, seasoned prosecutor, and meaningful arguments at the bail hearing. There's so many. And so there, you know, is a framework of those where, you know, the team of great people in this room and others can decide what are the priorities. But that is one of the critical elements, Judge, that you bring up, and you just naturally bring it up because you know it and you experience that having a seasoned prosecutor at first appearance and meaningful individualized bail hearings is a critical component of a successful, high-functioning pretrial justice system.
Hey, we got to cut our teeth somewhere. Don't leave off the green. Just because we're green doesn't mean we're useless, all right? Everybody here has been green once. But I get what you're saying, but you know, I'm squirming a little because I was that greenhorn walking in not knowing what a CRA was the first time I had a court appearance.
Madam President in the back.
I need it desperately.
I think the beauty of having discussions like this, and bringing folks in the room that haven't met before, haven't sat together to talk about these issues that we all care about, is that there are natural alliances. And I was just asking, are you aware of the judiciary and the Florida Sheriff's Association getting together in order to lobby for money for technology? And wow, that would seem to be something that could benefit obviously everyone. It's a safety issue. We need it, and that's something that you all need to talk about. If it hasn't been done, it needs to be done because the legislators seem to listen to you all, Sheriff, sometimes more than the judiciary, and certainly more than just us lawyers. So I think that would make a whole lot of sense to start those conversations and those alliances in order to help everyone in making those informed decisions that the judges need to make. But
I appreciate everybody so much, and thank you guys. So I guess we can definitely say we need some monies. So I think that would be a recommendation. So thank you guys.